welcome to our webinar, The Essentials of Purchase Money Security Interest. My name is Anu Shah and I will be your moderator. Joining us today is Paul Hodnefield. Paul is Associate General Counsel for Corporation Service Company and serves as the company's subject matter resource for UCC, real estate, and other transactional service matters. He is a frequent speaker and writer on UCC search and filing issues, and a 2013 recipient of the National Association of Secretaries of State Medallion Award. And with that, let's welcome Paul.
Thank you. The purchase money security interest, which is sometimes called for short a PMSI or a PMSI, is one of the most useful secured lending tools available to commercial lenders. The purchase money security interest provides benefits not just for lenders, though, but also for borrowers, because while it does provide a great risk management tool for lenders, it also means that borrowers can have better access to credit. Now, the way that the purchase money security interest works is by really encouraging investment by giving a super priority to the secured party that holds a purchase money security interest, at least with respect to the particular collateral involved. Now, before I cover that in much more detail, one thing I want to point out is that when it comes to obtaining a purchase money security interest, a quick glance at Article 9 would suggest that it isn't all that hard. It's actually, the requirements are fairly simple to obtain a purchase money security interest. And while these statutory requirements appear rather straightforward, it's not always that simple. There are plenty of ways for a secured party to lose its purchase money status if it doesn't fully understand and comply with all the rules. Now, what I'm going to do today is provide some of the basic concepts about the purchase money security interest. I'll begin with some basic concepts, then I'll move on and talk about issues related to the creation of a purchase money security interest, and then on to perfection issues, and then I'll address some very specific items related to certain types of purchase money transactions. If you do have questions, if you do have questions along the way, please just enter them into the Q&A box on your screen, and we'll be able to get to them at the end of the session. First of all, I want to start with some basic concepts. First of all, what is a purchase money security interest? Well, it's all about priority. That's what it really boils down to. Priority is the order in which conflicting claims are satisfied. Frequently, a debtor will grant more than one security interest in the same collateral, and the courts need an orderly way to sort out who gets what if the debtor ever defaults, and that's what priority is really about. Now, the general rule under Article 9 is that priority ranks from the earlier time of filing or perfection. So the first to file a financing statement is going to be first in line when it comes time, if the debtor should default, when it comes time to divide up the value of the collateral. Now, the priority is so critical in this context because of the way that competing claims are satisfied. The first priority secured party, as a general rule, is going to have its claim paid in full before the second in line gets a penny. So it's kind of an all or nothing deal. The first secured party gets paid in full. If there's any value of that collateral left over, then the second secured party in line will get whatever's left over, and on down the line until they run out of money or secured parties, whichever comes first. Now, the purchase money security interest is an exception to the general rule of priority. The purchase money security interest is a security interest in favor of either the lender of goods to secure the price of the goods, or the seller of goods to secure the price, or a lender, a person who advances funds to enable the debtor to acquire rights in the collateral. Now, if the secured party qualifies for purchase money security interest, then they get that super priority, and they get to jump to the head of the line when if the debtor should default. Let me illustrate how that works for you. Let's say that in 2010, the debtor granted its bank, secured party 1, a security interest in all of its assets, and the bank promptly filed its financing statement. A year later, in 2011, the debtor granted secured party number 2 a security interest in all of its equipment, and secured party 2 filed a financing statement to perfect its security interest. And then finally, in 2012, secured party 3 provided the debtor with financing that enabled the debtor to acquire a laser widget. And in exchange for that, the debtor granted a purchase money security interest in the laser widget, and secured party 3 promptly perfected by filing its financing statement. Well, in this type of situation, under the general priority rule, secured party 1 would have priority with regard to all of the debtor's assets. Only after secured party 1 was paid in full, if there was any value of the equipment left over after that, then that would be applied to secured party 2, and if secured party 2 was also paid in full, and there was still some value left over from the laser widget, then secured party 3 would get it. But more than likely, secured party 3 is not going to get a penny. In fact, frequently, secured party 2 won't get anything. There won't be enough money left. But with a purchase money security interest, assuming that secured party 3 did everything necessary to obtain a purchase money security interest, secured party 3 gets to go right to the front of the line there. And it will have priority in the purchase money collateral, the collateral it enabled debtor to acquire. So it will have priority in that laser widget. Secured party 1 then will have priority for all the other assets subject to the security interest. And finally, secured party 2 comes in at the end of the line, and as noted here, oftentimes being at the end of the line for priority is not a good place to be. It's probably not going to collect anything. So the stakes are very high in this regard. Some other essential concepts to understand about a purchase money security interest. First of all, a purchase money security interest isn't available for everything. It's available for goods, and it's available for software as part of an integrated transaction. It's available for fixtures, and fixtures are a type of good. And it applies to consignment transactions, and I'll come back to that as well. So really, it's applicable to tangible goods for the most part. It's not, you're not going to be able to get a purchase money security interest in the acquisition of a copyright, typically, or acquisition of a trademark right, intangible rights. Now, the secured parties that are eligible to obtain a purchase money security interest, of course, the seller of goods, as I mentioned, somebody that provides goods on credit and retains a security interest in the goods. It's also available to a lender that provides the value that enables the debtor to acquire rights in the collateral, assuming that the debtor uses the value for that purpose, and the consignor of goods in a consignment transaction. All those are eligible to obtain a purchase money security interest. Now, because a purchase money security interest is an exception to the general rules of priority, the courts and Article 9 itself place the burden of proving compliance on the secured party. So that the secured party is going to have the burden of proving to what extent their security interest is actually a purchase money security interest. So this is important to understand about a purchase money security interest. The secured party, by claiming an exception, an advantageous exception to the general rules, is going to have to be able to prove that they have complied with all the requirements. And with many of these requirements, it's got to be strict compliance. So the secured party here has a pretty hefty burden. And they have to be very careful to document everything with regard to the purchase money transaction so that they can prove in court. Because if they have the burden of proof and can't prove it, it's not up to the other party to prove that it's otherwise. Secured parties do have to be prepared to prove up that they do in fact have a purchase money security interest. Now let's go on and talk about the creation of a purchase money security interest. An essential start on that is the security agreement. There are cases out there where somebody has borrowed money to acquire goods and has used the money for that purpose, but the secured party did not get a purchase money security interest because they did it on a handshake. And merely loaning money for purchase money purposes does not create a purchase money security interest. And the case I used to illustrate that, CFB5, what happened here was the debtor actually owned an art gallery, and a friend of the debtor loaned the debtor money to purchase art for the art gallery, and the money was used for that purpose, and so some certain pieces of art were hung on the wall of the gallery, and debtor went into default, and other creditors tried to get at the assets. In fact, the debtor filed for bankruptcy. And because there was no security agreement, it was done on a handshake. The court said that there was, the requirements for purchase money security interest were not satisfied, and as a result, instead of having being able to exercise its security interest in the artwork that enabled the debtor to acquire, the secured party was treated as an unsecured general creditor. So there must be a security agreement. Also, a purchase money security interest is only a purchase money security interest to the extent it was a purchase money obligation and to the extent that it's purchase money collateral. What this means is that an obligation to repay a loan may include both purchase money and non-purchase money components. For example, if somebody takes out a $100,000 loan for the purpose of buying a $50,000 piece of equipment and using the rest of the money for other operating purposes, not the acquisition of goods, the secured party, it's only a purchase money obligation up to the value of the goods that the debtor acquired with that. Likewise, it's only a purchase money security interest to the extent that the collateral is purchase money collateral. If the loan covered other types of collateral, or it's secured by other types of collateral, it can only be, it's only a purchase money security interest to the extent of the purchase money collateral. So it may have purchase money priority with some collateral, but not with respect to others. One other issue with the a seller of goods to secure the price of the goods, what goes into the price? The courts have been kind of split on components. I mean, what is the price of the collateral? The general rule is it's the price actually paid for the goods, the sticker price, whatever the debtor paid for the goods. But there's other things that oftentimes go into a transaction which aren't technically the price. For example, what about negative equity? If the debtor is trading in a piece of equipment and the equipment is worth $8,000 as a trade-in, but the debtor owes $10,000 on it, it's not at all unusual to roll that $2,000 difference back into the new loan. And the question is that negative equity part of a purchase money security interest? Well, the courts have been split on that. In some circuits, the courts have said, yeah, it can be part of the purchase money security interest because the transaction would not have happened unless they had financed that $2,000, that negative equity. But in other circuits, they've come out differently. And the same thing applies to other types of fees that might be involved, like extended service contracts or certain type of insurance arrangements. The courts are somewhat split over whether or not these things can be considered part of the price. So much of it will depend on where the transaction takes place and where the debtor is located. Now, the transaction has to enable the debtor to acquire rights in the collateral. If the debtor already has rights in the collateral, there's a good chance that it couldn't be a purchase money security interest. That might occur in a sale-leaseback type of situation where the debtor owns equipment and sells it to a leasing company that in turn leases it back to the debtor. So in that type of situation, purchase money or that type of transaction may not be eligible for purchase money security interest. When it comes to actually paying for the goods, remember that the debtor must actually use the proceeds or of the loan that's provided to make the purchase money acquisition. The debtor must actually use it. And if they don't, then then for one, it can't be a purchase money security interest. But even if they do eventually use it, the secured party has to be able to prove that the funds that the secured party provided were the funds that were used to actually acquire the purchase money collateral. And if there's a discontinuity between the advance of the funds and the time that they actually are used, maybe the debtor advances funds one day, and 3 weeks later the debtor goes out and buys a piece of equipment with it. Well, during that time it's been commingled in a bank account and all sorts of things. Can the lender trace those proceeds directly to that collateral? Well, that's an open question. The courts will address that on a case-by-case basis. And because it can be difficult to trace those funds unless it's well documented, best practice is that lenders should always pay the purchase price directly to the seller, or in the alternative, cut a check that's jointly payable to the seller and the debtor. Because remember, it's the secured party that has to be able to prove that they've complied with the requirements for purchase money security interest. And if they provided the value but can't prove that the value was actually used by the debtor to acquire the goods, then there's a problem. So for that reason, it's always a good idea to have good documentation as far as payments go, where that money goes. Now I want to move on and talk about perfection of purchase money security interests and some issues that arise in that regard. First of all, what about the financing statement? Well, the sufficiency of any financing statement is determined by Section 9502, typically A in the case of a purchase money. Under Section 9502A, financing statement is sufficient if it provides the name of the debtor, name of the secured party, and an indication of the collateral. There are no special requirements for purchase money security interest financing statements. In fact, cases that have tried to claim that a party was not entitled to purchase money priority based on their financing statement that otherwise complied with Article 9 have largely failed. For example, Key Bank versus Huntington Bank, this is a 2002 case out of Ohio. What happened there was Key Bank had a blanket security interest in all the debtor's assets, and Key Bank made future advances based on the arrangement they had with the debtor, and before each future advance, they do a search, and then they go ahead and make the advance. Later, Huntington Bank came along, and Huntington financed the acquisition of 3 particular pieces of equipment for the debtor. And Huntington filed a financing statement to perfect its purchase money security interest. The financing statement didn't describe the 3 individual pieces of equipment. Instead, it just said equipment, which is a perfectly acceptable method of describing equipment under Article 9. Well, after the debtor defaulted and the parties wound up in court in a priority dispute over those 3 pieces of equipment, Key Bank argued that Huntington, by not particularly describing that equipment, was not entitled to purchase money priority because Key Bank would not have been able to determine what particular equipment was covered by that purchase money security interest. But the court said, sorry, but that's not the way it works. Article 9 does not have any special requirements for a financing statement with a purchase money security interest. The collateral description rules are the same. And we have a notice filing system, and any party that is conducting a search is responsible for looking beyond the public record to learn the full state of affairs. So Key Bank's argument there didn't work, and Huntington was entitled to its purchase money security interest. So the thing to remember about that is a financing statement does not need to indicate that it is filed in connection with a purchase money security interest. In fact, it can say purchase money security interest, but that doesn't make it so. What makes a financing statement, a purchase money financing statement, or I should say, what gives the secured party a purchase money security interest is compliance with the statute, not anything specifically noted on the financing statement. So anybody that conducts further inquiry beyond the public record is going to learn about the purchase money claim. They don't have to indicate that on the financing statement. It's all established by the secured party's compliance with Article 9. One of the things that's different about a purchase money security interest is that there are deadlines involved for perfection. A normal, a non-purchase money security interest has no deadline for perfection. A secured party can close a deal one day and they don't have to file a financing statement right away. They can wait as long as they want. Now, there are consequences that come with delay. They could lose priority but to somebody that filed in the interim. But there are no deadlines with regular, the common security interests. That's not the same with a purchase money security interest. With a purchase money security interest, the general rule under Article 9 is that to obtain the purchase money security interest, the secured party must file before or within 20 days after the debtor receives possession of the collateral. Now, there are some exceptions to this. Purchase money security interests in inventory, consignments, purchase money security interests in livestock, those all have different time limits. Likewise, there are some states, notably Nebraska and Tennessee, that have longer perfection periods, 30-day periods. And in the case of consumer goods, a purchase money security interest in consumer goods is perfected without filing. There's no financing statement required. But the important thing to remember about calculating the deadline when one applies is the trigger is the debtor's receipt of possession, when the debtor receives possession of the collateral. So how does one calculate that? It may not be always as simple as it might seem. Well, the general rule is when the debtor takes physical possession of the goods. And that gets delivered and signed for. Or if the debtor goes and picks them up or buys them and drives off with them, something along that line. It's usually not that hard to determine, but there are certain cases where it may not be as clear. There are times where a debtor can obtain goods under other law, not governed by Article 9, that can affect when they would become subject to a purchase money security interest. For example, in the case of a lease, leased goods, the debtor doesn't have any ownership rights in those leased goods, and under the official comments to Article 9, if the debtor decided to buy those at the end of the lease and obtain financing to do so, then the debtor would receive possession at the time the goods became collateral, as the term is defined by Article 9. The bigger question, though, is what happens when the goods are delivered in installments, as might happen with a large piece of equipment that has to be delivered in pieces and assembled and tested over time. Well, here it's more of a third-party point of view. Remember that the filing system, a lot of the Article 9 filing system is designed to protect third parties that were not parties to the agreement. So if the collateral is being delivered in stages for assembly and testing, the buyer generally is going to take possession when it would appear to a hypothetical creditor that the goods in the, looking at the goods in the debtor's possession, that the debtor has acquired an interest in the goods taken as a whole. So it's how it would appear to a third party. And let me kind of illustrate how this might work. Let's say debtor decided to purchase a large machine that had to be installed and tested. And the parts of the machinery were delivered, first one on January 15th, second one on February 1st, last one on March 15th. The assembly and testing of the components of this machine began on February 1st and ran through April 30th. And then on May 15th, the debtor finally signed an acceptance certificate and handed it over to the seller or the secured party, whoever is claiming the purchase money security interest. So when did the debtor receive possession of the goods? Well, we know the last possible date would be that May 15th date. But it's really up to the court to determine, based on all the facts and circumstances, of when in that period from January 15th through May 15th that a hypothetical third party creditor would take a look at the situation and decide that the debtor had acquired rights in the collateral. So it's probably somewhere between February 1st and March 15th, but you can't know for sure in advance. So best practice, of course, file the financing statement at the earliest possible opportunity. Nothing requires a secured party to wait until the debtor is signed off on it. Nothing, signed off on acceptance. Nothing requires a secured party to even wait until after the security interest or the security agreement has been signed. A secured party can file a financing statement before the security agreement is executed or before the security interest attaches. The only caveat to that is they better have permission of the debtor to do that. In the case of a purchase money security interest, it's probably a pretty good idea to file early rather than trying to calculate the 20-day window from some other little less clear point in time. Before I move on and talk about the special purchase money situations, I do want to talk about what happens if subsequent events affect the security interest. For example, what happens with a refinancing of the loan? Debtor goes into default and there's a workout or refinancing, something like that. Well, the general rule under Article 9 is that a purchase money security interest doesn't lose its status merely because the obligation is being renewed, refinanced, consolidated, or restructured. Unfortunately, however, none of these terms were defined in Article 9, so that's left to the courts to determine what these mean. There isn't a lot of case law on this since 2001, but there is one case worthy of note. Lewiston State Bank versus Greenline Equipment. What happened here is the debtor was a farmer and had granted a blanket security interest to his bank. And later the debtor bought 2 tractors from the manufacturer and financed those and granted the manufacturer a purchase money security interest. The debtor ran into some financial difficulty, and the dealer that sold those tractors originally decided to help out this farmer. And what the dealer did is the dealer, according to the dealer anyway, the dealer refinanced the tractors for the farmer. But how this happened was the dealer paid off the original secured party and then issued a new loan to the debtor, refinancing those tractors. Problem is that the court found it wasn't a refinancing. Once the original obligation was extinguished, the loan was a new obligation. So it wasn't a continuance of the original obligation. So the important thing to remember here for when the debtor, if the debtor is in default and goes into workout or wants to refinance, there's nothing wrong with refinancing or restructuring the obligation as long as it's the same obligation. Once that original purchase money obligation is extinguished, however, any new loan on that same collateral probably isn't going to be entitled to purchase money security interest status. So the important thing to remember again, it's got to be the same transaction or part of the same obligation, not a new obligation. In this case, had the dealer bought the loan from the manufacturer or otherwise taken an assignment of it, it would have been the same one, and they could have restructured it or refinanced it. But as it was, they extinguished that, and as a result, they weren't entitled to purchase money on their loan to the farmer. Well, again, the general rules of purchase money security interests has to be a loan made to enable the debtor to acquire rights in the collateral. It's a purchase money security interest to the extent that it's purchase money collateral and a purchase money obligation, and it has to be perfected by filing a financing statement before or within 20 days after the debtor receives possession of the collateral. Now, there are some special rules that apply in certain cases, and the most important is a purchase money security interest in inventory. Now, purchase money security interest in inventory must be perfected before the debtor receives possession of the inventory. So it's got to be perfected. There is no 20-day window in here. There is no 20-day rule. The secured party must perfect before the debtor receives the inventory. There is a notice requirement as well. This is to prevent situations where a debtor or a lender may be obligated to make future advances for acquisition of inventory, and the debtor could run off and essentially double finance the inventory by financing it both from the seller and from another lender that's obligated to make future advances on the inventory. So the way they deal with this is through a notice requirement. Secured party must send an authenticated notice to the holder of any conflicting security interest. Now, the recipient also has to receive that notice, and that's receive, it's not just send, but the recipient must receive it before the debtor receives possession of the inventory. Now, once it's received, that notice will cover deliveries of inventory for the next 5 years. The notice is effective for a 5-year period, and it has some content requirements that I'll come back to here in a moment. First of all, what is inventory? Well, it's goods other than farm products which are leased by a person as lessor. So the leased goods by a leasing company are actually inventory of the leasing company. If they're held by a person for sale or lease to be furnished under a contract of service or to be furnished under a contract of service, I mean, this is the classic definition of inventory. The stock of a store is inventory. If it's goods that are furnished by a person under a contract of service, all the repair parts that a repair company has, those would be inventory. And raw materials, works in progress, or other materials used or consumed in the business. Those are all considered inventory. Now, whether goods are inventory in a particular situation is generally determined by the purpose for which the goods are held. One case I saw that illustrated how the courts approach this was Buffalo Molded Plastics. This is one where Buffalo Molded Plastics was a manufacturer of automobile components that they sold to GM. And following a common practice before the GM bankruptcy, I don't know if it still is, but what would happen is GM would agree to buy the manufacturing equipment for particular components. Actually, they would have the right to buy it in case the debtor went out of business. That way they wouldn't they wouldn't have a break in the supply chain if the manufacturer went out of business. They could just take the equipment and give it to somebody else. So Buffalo bought some manufacturing equipment from from the company that provided it, the seller, and everything was fine until Buffalo wound up in default. And what happened there was that one creditor of Buffalo challenged the purchase money security interest claimed by the seller of the goods by saying that this was inventory of Buffalo because they were going to resell the equipment to GM at some later time. And of course, the seller of the goods disagreed with that. It never reached a decision by the court, but the court laid out how they make the determination of whether the goods are inventory, and that's, for what purpose is it being held. If it was being held for resale to GM, then that equipment probably would be inventory. But if it was being used primarily for the manufacture of goods, then probably not. But again, it settled before the court ever reached a decision on it. Now, when sending a purchase money security interest notice, the first step is to conduct a search. The idea here is it's necessary to identify who needs to receive the notice. And because of this, the search has to be done, ideally anyway, after the filing of the financing statement. And that's because if the financing statement is filed to perfect the security interest sometime after the search is conducted, there's a possibility that another lender could have snuck in there during that period. And if that happens and that lender doesn't get the notice to which they're entitled, that can affect the purchase money security interest. So it's always a good idea to wait and conduct the search after the financing statement has been filed. So it's also a good idea to make sure that the through date on the search, when the state's index has caught up to the file date, make sure it's on or after the file date. When interpreting the search for purposes of sending purchase money notices, you don't need to send them to anybody that has a lapsed financing statement, but any financing statement that's been amended or even terminated, it might be a good idea to send a notice, even if it's been terminated but it's still unlapsed. Lapse and termination are two different concepts. Also, if the collateral has been amended or restated so it doesn't appear that the inventory is still covered, probably still a good idea to send notice. Of course, that's in an ideal world where the costs of due diligence really don't matter. But you always do have to balance, I guess, to a certain extent, the costs of sending the notice versus the risk involved. But as a general rule, in an ideal world, better safe than sorry. So who actually gets the notices? Well, of course, the current secured party or parties of record on a financing statement that covers the same collateral certainly have to get the notice. If a secured party has been deleted from a financing statement that covers the same collateral, again, in an ideal world, you would send a notice to that deleted secured party, but technically it wouldn't be required. If a secured party is the collateral agent, like on a syndicated loan where there's multiple participants, the sender of the notice is entitled to rely on the name and address provided for the secured parties on the financing statement. They don't have to do additional research to identify each additional secured party that isn't listed on the financing statement. And if there has been an assignment, it's important to understand that an assignment in the UCC records only assigns the right to amend the financing statement. It does not assign the security interest. And therefore, both the assignor and assignee need to receive the notice for purchase money. When it comes to calculating the deadline for sending the notice, again, bear in mind that the receipt of the collateral by the debtor is the absolute deadline for sending that notice. So send it as early as possible, preferably before the debtor is going to receive possession of the goods, and make sure it's received before they receive possession of the goods. If the debtor never receives possession, then a notice isn't really required. But bear in mind that the debtor may take constructive possession, even though they've never taken actual possession of the goods. They might have constructive possession. There's one case out there where the debtor had the goods segregated at its customer's location and under its complete control, and that was deemed to be constructive possession, which required the secured party to send a notice. As far as the notice requirements go, the secured party has to strictly comply with those requirements, or it may not be able to assert its purchase money priority. So the best practice, send the notice by, so that in a manner that provides evidence of the time of receipt, preferably by a signature. So usually the best method is something that provides proof of delivery, because remember, that secured party has the burden of proving that it complied with all the requirements for purchase money security interest. So typically certified mail or overnight delivery is the best method. Those will get a signature and time of delivery typically. Now, when does the notice need to go out? Remember, it has to be received before the debtor receives possession of the inventory. Once it's received, it's effective for 5 years. What happens at the end of that 5-year period, though? If the secured party is going to file a continuation on that financing statement and they want to continue to receive purchase money priority in any inventory that they provide during that continued period for the financing statement, then they are going to have to send a new notice. It's not a continuation of an existing notice, it's a new notice. Also, the new notice is not tied to the continuation statement. It can be sent at any time. There's no 6-month window for sending the new notice. Once it's received, it will cover inventory delivered during the following 5 years. So if it's sent a year before the financing statement is continued, that's great. It'll continue to cover the deliveries of collateral. You just got to be sure to track the expiration date of the notice separately from the expiration date of the continuation, because there are no necessary connections between the continuation statement of the UCC financing statement and when the notice has to be sent. So for sending the new notice, best practice, first of all, conduct a search so that you can purge any secured parties that have let their financing statements lapse from the notice list, and then send the notice so it is received before the 5th anniversary of the last date, or of the date the last notice was received. So here's how that can work in practice. Let's say we have a financing statement filed on January 15th, 2012. That means it's going to be effective until January 15th, 2017. The notice was sent on April 1st, 2012, about two and a half months after the financing statement was filed. And that will be effective until April 1st, 2017. So the secured party is going to be able to get purchase money priority only from April 1st to January 15th. Now, to get purchase money priority beyond that January 15th lapse date of the financing statement, the secured party will have to continue the financing statement. But if it doesn't send another notice, it will only get purchase money priority until April 1st, 2017. So it has to send the new notice that's received before April 1st, 2017. As far as the notice contents go, it has to say that the sender expects or has acquired a purchase money security interest in the debtor's inventory. It has to include a description of the inventory, and it has to be authorized by the secured party. Now, what does it mean to be, now it has to be authenticated. The notice, it must be an authenticated notice. That doesn't mean it has to be signed by the secured party. There have been cases out there where something less was required. The first financial case I cite here the notice was determined to be authenticated when it was sent on the secured party's letterhead, had the full name and address of the secured party, who to contact with any questions, and so that was sufficiently authenticated, even though it lacked a signature or even an employee name. It has to include a description of the inventory. There are no special rules for how to describe inventory in a purchase money security interest notice. So best practice is to just follow the standard Article 9 collateral description sufficiency requirements. It doesn't have to be a specific description either, as I mentioned. It can be by type or category. It doesn't have to be specific. Now, we actually get a lot of these purchase money security interest notices because oftentimes the sender follows that better safe than sorry rule, and they send them to the name and address in the return to of financing statements that show up on the search which is actually meant for filing office use so they know where to send the acknowledgement copies. So we see a lot of these notices, and what I've done is put together an example. It's kind of a composite of the common features that all these notices have. Each one's a little bit different, I've noticed, but they have that the notice is sent typically pursuant to the UCC, and then they'll cite the section of the UCC. And then it explains that the secured party either has or expects to acquire that purchase money security interest in inventory, and then they will provide a description of the inventory and provide contact information in case anybody has questions about it. Now, a livestock purchase money security interest is actually very similar to inventory, and I'm not going to spend a lot of time on it, but the only real difference between a purchase money security interest in livestock and one in inventory is that with livestock, the notice is only effective for 6 months. It's not effective for 5 years. Purchase money security interests are available for fixtures, but there are some different rules involved. With fixtures, in order to get a purchase money security interest in fixtures, the debtor must have an interest of record or must have possession of the real property involved. The security interest must be perfected by a fixture filing before the goods become fixtures or within 20 days thereafter. The trigger date here is not when the debtor receives possession, but when the goods become fixtures, which is sometimes a difficult determination. So, that's kind of a not always a very clear date like it might be if it was when the goods were delivered. Now, it must be perfected by a fixture filing, which is a defined term under Article 9, and that means a financing statement covering fixtures. It has to satisfy the requirements in Section 9502A and B for filing in the real estate records, and it must be filed in the office where a mortgage would be recorded on the affected real property. So by definition, a fixture filing is filed in the real estate records. Filing a financing statement on fixtures with the central filing office of the state where the debtor is located does not perfect a purchase money security interest in fixtures under this rule. I mentioned earlier consignment transactions. Consignments are within the scope of Article 9, or at least some consignments. Article 9 does define what consignments fall into it. And under Article 9, if it is a consignment transaction within its scope, the consignor's interest in the consigned goods is a purchase money security interest in inventory. Here's why. A consignment is a transaction where a party, the consignor, turns over goods that the consignor owns to a consignee to allow the consignee to sell them. So you might have heard of consignment shops and things. Somebody's turning over goods to another to sell on their behalf. And in this type of situation, the consignor's interest, once it's turned over to the consignee, is a purchase money security interest in inventory. And that's because the consignee is deemed to have the same rights and title to the goods as the consignor. That's how the consignee can transfer title to the goods in that type of situation. And because the consignee is deemed to have the same right and title as an owner, the consignor, that means that creditors of the consignee can reach those consigned goods to satisfy their claims. So in order to prevent other creditors from going after consigned goods, the consignor must comply with the purchase money security interest in inventory requirements. So they have to perfect by filing a financing statement before the debtor receives possession of the goods. They have to send a notice to the holder of any conflicting security interest in the goods and make sure that notice is received before the debtor receives possession of the consigned goods. Consumer goods. No filing is required if the collateral consists of consumer goods. It's perfected automatically without filing. But the determination of whether goods are consumer goods is important here because some consumers buy goods that you wouldn't ordinarily think of as consumer goods. Consumer goods are those acquired for personal, family, or household purposes. But is a tractor a consumer good? It might be. A bobcat, one of those front loaders, that can be a consumer good. And how does the lender know for sure whether it's a consumer good or not? It can make a difference, because if they don't file because it's a consumer good and it's later determined not to be a consumer good, then they're unperfected. Well, the courts actually give the lender a fair amount of leeway on this. They allow the lender to rely on the borrower's representation. So if in the loan documentation the borrower represents that the goods will be used for personal, family, or household purposes, then generally that's all that's required. The secured party doesn't have to do anything more. There are some non-uniform purchase money security interest rules out there. Florida does not allow for a purchase money security interest in fixtures. Kansas does not have a consumer goods exception for the filing requirement, so you have to file even on consumer goods in Kansas. A purchase money security interest in fixtures in Louisiana must be filed in the regular UCC index, and there is no 20-day rule. So always important to file as early in Louisiana as possible. And Tennessee and Nebraska, as I mentioned, they have a 30-day window for filing the financing statement related to the purchase money security interest. Although Tennessee is they've filed bills the last couple of years that would extend it out to 90 days, but they never made it through the legislature. That would be really great for secured parties, because they'd have 90 days to perfect a purchase money security interest, but not real good for those that search the UCC records, because there could be hidden liens that pop up and take priority up to 90 days after the date of the search. So I don't know whether that type of bill will get any traction in future years. So in any event, those are a lot of the issues that arise in the context of purchase money security interests. I tried to hit the things that people ask the most questions about. At this point, I'm going to turn it back over to Anu to take your questions. So Anu?
Thank you, Paul. That was great. So we will now open up the Q&A session. For the sake of time, I'm going to skip over any other closing items that we have. The only one thing I want to mention is that on the screen we have a poll question for you. Would you like to be contacted by a UCC specialist? You can make your selections here and somebody will be in touch. So Paul, let's get right into it. Patrick is asking, does the priority of a purchase money financer attach to proceeds?
It can, identifiable proceeds from the purchase money collateral. But it doesn't to the same extent. I mean, it depends on the type of proceeds and whether they're identifiable. So really it has to depend on the particular situation.
Okay. James is asking, in the case where the bank finances an 80-20 purchase of a piece of equipment, if the bank were to send its 80% of purchase price directly to the seller of the equipment, and the debtor were to send the remaining 20% to the seller, does this jeopardize the PMSI?
No, because the obligation, the seller is still financed. The purchase money obligation, it's purchase money collateral. I'm frequently asked, well, is there a point where a down payment becomes so big that it would jeopardize the purchase money security interest? And typically no, because it's to the extent. That's what the code says, to the extent. So to the extent it's a purchase money obligation, and to the extent it's purchase money collateral, it's a purchase money security interest. So in that type of situation, the secured party has provided value, it's enabled the debtor to acquire rights in the collateral, and that type of transaction structured that way shouldn't have any impact on that.
Thank you. Chris is asking, is notice to senior secured parties only required for inventory?
Inventory, livestock, and consignment transactions, which of course are treated as an inventory purchase money security interest. That's correct. It's not required for other types of goods, just inventory and livestock and consignments.
Thank you. Christine is asking, she wants to confirm that the notice requirements is only for inventory. Notice is not necessary for purchase of equipment or other collateral that is considered inventory. I think you just went over that.
Yeah.
Okay. And a follow-up question from Christine. So if the debtor does not own the where the fixtures will be installed, then a secured party may not perfect the PMSI in fixtures?
Well, they either have to have an interest of record, which means that they're in the grantor-grantee index either as an owner or a long-term lessee or some other real estate interest, or they have to be in possession of the real property.
Okay.
If neither of those apply, then they're not entitled to then a purchase money in fixtures may not be available.
Thank you. John is asking if a bank finances a billboard and its fixtures, but the customer does not own the land their billboard sits on, are we still covered?
Typically, as long as the billboard is an asset, I mean, a billboard can be moved, not easily, of course, but it would depend on the particular facts and circumstances of the arrangement between the landowner and the owner of the billboard. But, as a general rule, there's no reason why somebody couldn't get a purchase money security interest in that type of case, either as a fixture or as in personal property, if it's not a fixture.
Okay. Timothy is asking if a secured party has a ABA filing and later modifies to a PMSI, can they later change this back to an ABA filing by modification, or do they need to refile to perfect the ABA filing?
I am going to have to assume here that ABA means all business assets. If I'm wrong, shoot us an email afterwards and we'll answer the question. But actually, all business assets would finance a later, or would cover a later PMSI. A PMSI wouldn't even be necessary because the secured party is in first priority to begin with, unless there's a prior secured party. But an all business assets or all assets filing would cover purchase money security interest. There's no requirement to indicate that it's a purchase money.
Thank you. Charlene is asking, what if they didn't send the notifications when they filed the continuation of the financing statement? Can they send now to secure interest?
Yeah, you can send the notice later. It's just that any inventory delivered, the inventory and advances delivered during the period when the notice wasn't in effect won't be entitled to purchase money security priority.
Okay, thank you, Paul. So that is all the time we have today. If we didn't get to your question, we will contact you with the response after the webinar. Thank you to everyone who joined us today. We hope to see you next time.